Well, welcome everyone to this week's edition of Feeling Smarter. Once again, I've got Tim next to me. So, welcome, Tim.
Hello, Aaron.
Who would have thought?
Who would have thought?
Well, today we're going to talk about the very exciting topic of sort of related party transactions, but in a slightly different tack, because related party transactions, things haven't really moved when we look at investment rules and restrictions over a long period of time, yet they seem to continue to regularly get caught up in decision impact statements and the way in which the ATO looks at transactions. And I think the biggest thing in my mind that comes out from this is the fact that in many instances we look at these particular rules and restrictions in isolation.
Yep.
So can I get you to maybe elaborate in the first instance as to some of the examples we've seen recently and why the ATO takes this view and not looks specifically at the isolated transaction that might seem good in theory, but ultimately creates some fairly significant problems in other aspects of the law?
Yeah, look, I guess it's an interesting one, isn't it? Because as you say, the investment standards, the investment restrictions have barely moved since basically since the turn of the century.
Yes.
Where we actually had the introduction of a lot of these related party rules from 1999 onwards. So we've seen limited recourse borrowing arrangements, we've seen collectibles and personal use assets, but a lot of the other rules around things like financial assistance, with other things like sole purpose test, acquisition of assets, all those things, in-house asset rules have all largely remained the same. But what obviously has occurred in that time is that there's been, I guess, a greater emphasis placed on the linkage between the SIS Act and the Tax Act.
Yep.
And so, where transactions sort of sit with regards to a compliance point of view, does this transaction comply with the superannuation law, and a very specific section of the law, and then does it apply more broadly to the other investment restrictions as well? And so where we see, and probably what led us to this conversation today, is that there's been this recent one where the court ruling has been provided with relationship to the disqualification of a trustee, was in the Merchant versus the Commissioner of Taxation, and Mr. Merchant was one of the co-founders of Billabong. And this whole thing stemmed from the fact that his self-managed super fund purchased Billabong shares from effectively the Merchant Family Trust. Now, in isolation,
looks all good, doesn't it?
Looks all good. Acquiring
listed equities on an approved exchange, no problems.
That's right, at market value.
At market value.
Right. It just so happened that market value was about $55 million lower than what the family trust had paid for them.
Yes. Which equally he was to have a distribution, if I wasn't mistaken, that was slightly higher, but somewhat was going to be alleviated by this capital loss.
Yeah. So discounts in trust on sale of another family trust asset was around about the 100 million mark, and when you applied discounts to it ultimately cancelled each other out. So the loss within the family trust on the sale of Billabong to the super fund was fairly substantial, because it provided, ultimately, in the tax officer's view, financial assistance to Mr. Merchant. But further than that, they looked at the sole purpose test. And from a sole purpose test point of view, they say, well, what is the purpose of this transaction? Is the purpose of this transaction to provide for retirement benefits for the member or their beneficiaries? Or is there some other underlying purpose? And they said, well, in this instance, the underlying purpose, the primary purpose, whilst they can undertake the transaction, the primary purpose of this is to get a tax benefit.
Yeah, so it's been tax driven rather than retirement benefit driven.
Correct. And so the client had received advice, right, formally or informally, but had received advice to say that there is no issue with the acquisition of these assets from a related party, that is in accordance with the law, but there may be some taxation considerations there. So, felt that the whole transaction was appropriate. The other side of it too is that by obtaining that effectively in that tax neutral position in the family trust, that provided him with a tax neutral position personally, which ultimately meant that he was being provided with financial assistance by the super fund. So in essence, the tax office said, well, you're in breach of the sole purpose test. you're in breach of the financial assistance, and you're also in breach of the operating standards, because to have that many of the one share is outside the scope of your existing investment strategy.
Yep. So we're looking at Reg 409 there
yeah,
specifically.
that's right,
Yep.
which is a direct link on from Section 34 under the
Yep.
operating standards. And so basically they disqualified him as trustee, but deemed in the same conversation that he was actually a fit and proper person, but he was disqualified because he had breached a section or multiple sections, and they felt that it was, if people have repeat behavioural things, they want to look at where that might sit from a public perception with reference to whether or not it poses a risk to anybody else. Now, he appealed the disqualification, didn't appeal the sole purpose test, didn't appeal the financial assistance elements of it, appealed the disqualification, and ultimately won, because the tribunal determined that, one, as the tax office had already indicated that he was a fit and proper person, the fact that they're taking, yes, a large transaction, but it was only one event, and it was one event in which he had obtained advice to say the actual transaction itself
ticks the box,
was not in breach of the legislation. So he's able to act as trustee with some conditions put in place, but it does bring us back to this whole position of related party transactions, and there's multiple other ones. We've seen the BPFN case, where there was multiple loans to related entities to then subsequently be lent out to unrelated property developers, and the tax office and the courts determined in that instance that the dealings weren't at arm's length, but the income that the fund had generated was no more than they would expect them to obtain in an arm's length transaction. So we're seeing a greater link to the outcomes of the transaction from a tax and a financial position, versus the specific, can one element of this satisfy one requirement of the SIS Act. And so, we often look at things quite narrowly, but we certainly have to take a far broader approach. And if you go back to all of the rulings of sort of 2008, 2009, most of them say, in isolation, this is a situation, but you have to consider in-house asset rules, sole purpose test, all those other areas.
And this goes back even when we think about the ORBA, the related party transactions, and why the ATO brought in the safe harbour.
Yes.
Because of the fact that we had the arm's length requirements having been set aside because the terms were more favourable to the fund, but really didn't give any consideration to the tax aspects of what 295/550 spoke about. And then quite clearly the ATO said, well, you've opened up the door trying to walk in on this side, but as soon as you've shut it, you've actually blown out all the other income tax issues that sit out the back of that as well. So it's a really good reminder to, when you look at these sort of transactions, related party transactions, I think is a common one, that you're going, you need to first and foremost be satisfied that the objective that is trying to be achieved is focusing on a retirement outcome.
Yes.
Tax is a driver. We get that, but it needs to be somewhat ancillary and needs to be part of it, but not at its absolute core as to why that transaction may have occurred in the first place.
Yeah, absolutely. And look, and probably to summarise it, in the one case that takes a different look at it all, which was the Aussie golfer situation, where ultimately the client won out in regards to the ATO breached them on the sole purpose test, but they actually won that because they could show that their investment strategy had considered student accommodation, and there was certainly no financial detriment there. So whilst there was actually in that instance a breach of the in-house asset rules, which was then required to be rectified in that regard, from a sole purpose test, the tax office sort of were shown to be, I guess, overreaching in saying, well, the only reason you did this was to provide student accommodation to your family member, whereas they said, well, actually we had multiple other tenants in the property, and the commercial income was the same across the board. So actually this is satisfying the requirement. And what we do see with all of these is that when the tax office win, right, they're very hard as to how the rules go. And when the tax office lose, they tend to come out with
decision impact statement.
Impact statement.
You beat me to it, actually.
And that decision impact statement is like, these circumstances don't apply to anybody else.
Yes. Yeah. So it is a very good reminder, once again, that these sort of transactions, fantastic to be able to work within the construct of the various rules. Like I said, related party acquisitions is one area.